Thanks again for joining us. This is the Art of Law webinar series. This is part 2 of a JV Disputes. Part 1, you can find it on the YouTube channel. There's a link here. And after the video, after this presentation, I will send you a link to the video as well as a copy of the PDF if you like. And as always, if you have any questions, just put it in chat. We are very welcoming to audience input. We don't want to just be preachers here. And just a quick recap on episode 1. Basically, that was about the common mistakes during JV disputes. Going through it very quickly. Mistake number one is needing total control of a joint venture, which in practice is just it just really doesn't matter if it's crumbling. Number 2 is playing the wrong game, looking too much at the contracts when other things are quickly going under around you. Number 3 is not using a pirate captain and just relying on the same team that got into the mess that mess. And number 4 is not looking at other sources of information, such as WeChat or doing interviews with employees, these types of things. You can't just strictly rely on the contracts. So with that said, I want to start off with going back to the roots of this whole series, where we're talking about China back then and China today. Mark, I found a book of yours, and here's a copy, and it's a very good story. Basically, it was a man took pictures of Shanghai back in the 1990s, around there, and because he didn't have enough time to draw, so they found his treasure trove of pictures, and his son ended up going to the same places to take pictures, to take updated pictures in 2004. So Mark, I'm sure you've seen some of these.
Sean, can you hear me? Because I think some people are having trouble connecting to the audio. There's in the chat. Can you hear me, or?
Yeah, I can hear you.
Okay.
All right.
So yeah, well, I don't know what to do. Okay, we'll just have to do our best then. Yeah. So I mean, obviously, I mean these. So some can hear, some can't. We'll have to look into it afterwards. So I think this was an interesting book. Showed a lot of the changes, and it was quite striking. And obviously, 2004 is 16 years ago. So probably from that same photo will be much different yet again. I think you can see the Shanghai Stadium in the background, but I guess it does kind of show how much things have changed.
And I think the reason why I wanted to put these pictures up here is because even though we're talking about JV disputes, I was having to think about it when I was putting this presentation together. Is it's inherently a very person-to-person matter, even though it's about two businesses. You're dealing with people at the end of the day. So a lot of the points that you touched on in the last episode, as well as what we'll cover in this episode, kind of bring that back into context. Here's another picture. I mean, it's really amazing. I was thinking about it when I was looking at the pictures, is that if you're dealing with a general manager or a Chinese partner that's 50 years old or something like that, they would have seen China grow up like these pictures here in front of your eyes. And Mark, you've been around for quite some time, so you've seen China grow too.
50 years is very young, Sean. We have to just tell everybody 50 is it's very young.
Yeah. And so and this is Xu Jiahui, which of course looks like this now. So with that said, Mark, I want to go back and I want to explore that theme of Shanghai, China back then versus back when it was growing to when you came, and bring it back full circle to where it is today. So JV disputes, let's step away from the legal part of it for a second. The law has inevitably has changed a lot, and courts too. How was it back in those days? What was your experience like handling confrontation and disputes in a day when it wasn't as developed.
Yeah. Okay. Yeah. So look, I think, firstly with those disputes, I'd say back in the 90s, the early 2000s, it was pretty rare to really have disputes which were open like that. It was more, everything was negotiated. I don't think you'd go to the courts. You wouldn't really even go to the authorities very much. It was really between the parties. I guess if we're talking about joint venture disputes, almost all joint venture disputes were negotiations about how much would the foreign party pay to buy out the Chinese party. I'd say that would be the case until maybe 2005, 2010. So I guess we're just talking about between the parties. I think it used to be the only thinkable solution to a joint venture dispute would be that the foreign party would have bought out the Chinese party. But nowadays, I think we see more and more it's the Chinese party buying out the foreign party, or somehow they separate from one another. So I guess between the parties, it's quite different. And then I think when we talk about courts, litigation's a much bigger thing now. It's, like we'll discuss a bit, there are issues with litigation in China, but there's issues everywhere. But I think now you're much more likely to see court cases being started, like much, much more likely. And the courts, are much improved. Back in the early 90s, I think the courts, we had very little contact with the courts, but when we did, they weren't really that professional. A lot of the judges were ex-military people. I remember one case we had early on, we turned up, because I was acting for a foreign law firm, and I was a bit more of an observer. And I asked the Chinese law firm who I was working with, because the other side's lawyer came in, and then he came in, and they had a very happy chat with each other. And I thought, I'm starting to really understand China a bit. So I was thinking, is he your classmate or something? He said, no, he's my colleague. I said, he's your colleague. And so they both acted for the same law firm, even though they were representing, the opposing parties, which I guess, kind of led to their motto, no doubt, that they've never lost a case. But so stuff like that would not happen today. But back then, those kind of things did happen.
So, does that lend credence to what you were saying before, where foreign parties tend to go about these disputes too mechanically, looking at contracts, looking at documents, whereas, let me know if this is a stretch, but the Chinese partners and companies have, this relatively short history of actually dealing with courts in a formal sense, and have more of a experience, doing things beyond the legal system.
Well, I don't actually really think it. I think, perhaps one of the things which we'll discuss a little bit is, I think really the biggest problem is in this whole disputes thing is that nobody is really good at resolving the disputes, I don't think. So I think, what is really the case is, the system here rewards status quo to a degree. So it's very hard to get momentum behind something. So the Chinese party, they are also not the greatest at doing, different kind of tactical things or whatever, but they've got that home court advantage. They've got the people, they know the system, they know, and I'm not even saying they know it in, a improper way. It's just, it would be similar to if a Chinese company wanted to wage a war against their joint venture partner in Germany, they would find it very difficult. They're not there the whole time. They can't make decisions quickly. They don't understand it. They have to talk to lawyers. Lawyers are inherently conservative. You get 1,000 different answers on everything. So I think it's probably more that home court advantage, the familiarity, knowing how things work, rather than the Chinese companies being particularly good at dealing with courts or anything.
I think we'll cover that a little bit more in the next couple slides, but just in case you are interested, this is the book that we took the pictures from. All right,
so just one thing, obviously go back to that slide. Obviously Shanghai's skylines improved a lot. Obviously it was a very polluted day when they showed that one.
Yeah, maybe it was a cloudy day.
Yeah.
All right, so
It's a great
So why
picture
don't we
for
just
a picture book, actually, a great cover for a picture book.
so why don't we get into it then, Mark?
Okay, please. Okay, so you want me to kick off or?
Yeah, sure.
Okay, so look, I think the first part is a bit about strategic planning. And I think for many of our Western clients or international clients, the first instinct when they've got a dispute with their Chinese joint venture partner is to whinge. So firstly, they will spend a lot of time talking to you about really the Chinese are being very naughty. We really don't like what they're doing. We really would like them to do something else. And yeah, that doesn't really work. So I think the issue is because they find it difficult to persuade people just to change their behavior, they will then start talking to lawyers, and then they'll start filing papers with a court. And I think the real reason is, and I think I would have touched on it last time as well, it's a bit that this problem is difficult to solve. So they actually just outsource it to a judge, which is very unfair because, yeah, if you can't solve it between you and your partner, how the hell would the judge know what he's up to? You know, he won't know the whole thing. And, you know, judges, it's not like they can really say, you go in the naughty corner or you behave or you be a better person. These things are all, you know, difficult to do. So that means the biggest risk I see in these disputes is the status quo, the gridlock, and the absolute loss of momentum. So once you get lawyers involved and even worse, the courts involved, then it gets bogged down and it's just about, I write to you, you write back to me, and especially the international company, because they're not on the ground. In most joint ventures, they don't really have the, the momentum within the company. Like they're not really running the whole thing very often. And so it becomes about exchanging letters, but not really winning the case. Okay, so so I think, you know, when you're looking at the joint venture dispute very early on, you have to predefine what results you would consider a success. And if you're going to say, well, if the Chinese guys would really just do what I would like them to do, that would be great. That's not really a realistic goal. You know, you need to work out what your goals are. It might be, I want to get out of this company, or your goal might be, I want to take over that company, or maybe, you know, you want to get things back. So I think that's, you know, the issues. So,
yeah, so I just think it's really interesting that what we just talked about with the changing Shanghai section is that the courts back then weren't developed, and of course a lot of things were negotiated, and the addition of more complicated proceedings really did not fix that to a great degree. So in order to go about actually getting the result you want, you need to look at, well, you know, what do you want? What is the objective?
Yeah, so some of these objectives, I think we had them last time as well. So, you know, different ones are different things. So, you know, let's say you want to keep within China. So like I said, you know, back in the late 1990s, early 2000s, buying out the Chinese partner was the only real option. Everybody knew it. And so actually these disputes were less toxic than they used to. It used to be not as bad as they are now. I think they're much more difficult today in many ways because it was clear. And the only thing you're really arguing about is how much you're going to pay and what kind of relationship, you know, you're going to have continuing on. It's a little bit like, you know, Brexit. You know, they've made a decision to leave, but you don't know exactly how, but you kind of at least know the parameters, which doesn't make it easy, but at least you kind of know what you're doing. The other one would be, you know, very often in joint ventures, a lot of people want exclusivity from the Chinese partner, which I think is often a mistake. So I would prefer to have exclusivity wrapped up in the technology rather than in a contractual relationship, because the Chinese side can normally get out of that exclusivity obligation, and it's often your core business. And so, yeah, obviously it would depend, and we still do exclusivity obligations in contracts, but it's something you should look at. And this is probably the second biggest issue for foreign companies is, how do this joint venture is a failure, but as long as it's still alive, I'm stuck in this exclusivity obligation. So, you know, I've got a small joint venture somewhere in Sichuan province, and that's stopping me from entering into China and doing other things. So that's one. Another one would be, doesn't happen that often, but sometimes there's these global deals, and it's so much more complicated if you're exiting from a business unit because of a global deal. And look, if you talk to a lawyer, there's a big risk that the lawyer will say, it's okay, you're selling, say, the Singapore company, which holds these companies. You don't need to get Chinese approval. You don't need your Chinese partner's approval. But we've seen a number of cases where the Chinese partner was very aggro that, basically he woke up one day with a different partner, and, legally it was difficult, but, telling the Chinese partner he couldn't do anything legally didn't stop them embarking on multiple litigation or other kinds of things. So, so there's lots of reasons to exit, but you've got to work out what you want to do and then really plan your strategy to solve that. So perhaps, the less ambitious you are, let's say you just want to protect your IP, you just want to get your production equipment back out of China, that's a much easier way to negotiate than if you want to buy out the company or you want to get them to buy you out.
And I just want to, I forgot to mention, I wanted, a few episodes ago, we did a video on joint ventures and the rise of joint ventures again, which is one of the reasons why we're discussing the dispute. So with the rise of joint ventures, probably the disputes are going to follow very closely. So Mark, once you understand which of these objectives you are going after, perhaps you start, well, maybe you've narrowed it down to maybe 3, 4, 5 options. How do you go about normally planning the strategy for those options?
Well, I think, I don't think you can plan it that way. You can't really work out too many of those options. I think the thing is, first question is, can you get out of the joint venture? Like, do you just want to run away? Because you can't even just run away from a joint venture. Your name's on it. It's not like you just close your eyes, click your heels 3 times, and you're out of it. So, I mean, I think that, the ones which are less likely is, people say, I'm going to tip it into bankruptcy. This is very difficult. Forget about your reputation issues. It's very difficult to get somebody into bankruptcy if they don't want to be bankrupt. And then liquidation of the company. This is another thing people like to say, but liquidation will rely on the Chinese partner cooperating a lot. So I think, the whole issue is, if you can get away from the feeling of being hard done by, you really have 3 options. One would be you buy out the Chinese partner, or you sell out to the Chinese partner, or there's some kind of arrangement where you say increase your interest from, say, 50% to 90%, and the Chinese partner stays in as a small partner. Maybe there's some supply arrangement or some other strategic arrangement, and then it is easier to understand why the foreign partner has the lead in making all the decisions. And maybe even the Chinese partner will get some kind of fixed dividend. There's ways to do that as well. So I think, it's just to take out those issues. Now, all of those things are harder to deal with if you've got a toxic dispute. So I think, my first thing would be to say, before it becomes toxic, before you start issuing lawyer letters, before you start going to courts, if you can diffuse it, it'll be much easier, much cheaper. So most people will land in a similar or worse position because they wanted to be throwing punches around, and it will take them 3 or 4 years maybe, and it will cost them a lot of money, and it won't be very good. So, if you can diffuse the situation, that would be the best.
This is a pretty relevant question, so I'd like to bring it up to you right now. Jack is asking if, regarding the offshore parent company change, is it standard procedure for a JV contract in China to have a change of ownership clause, which would solve some of these problems?
Well, I think that's the issue. I'm glad he asked that question, because it showed I didn't make my point that clearly. So, change of control provisions are relatively common in a joint venture contract. But a change of control provision is, if I have a joint venture with you, I can't sell my shares to a third party. It's a very common legal thing to have everywhere in the world, but in China, it's probably not really that necessary in a joint venture, because I can't sell my shares without your assistance anyway. And even if I have a provision expressly saying I can sell it to an affiliate, it's a long way. You have to go to court to enforce it. What I'm talking about is if a company has a holding company, let's say in Hong Kong, and it holds several different companies around the world, yeah, and they sell off that whole holding company to another party. So for the China joint venture, the joint venture partner hasn't changed. Possibly it won't even change the name of the company, but the underlying ultimate parent has changed. And we've had a few of these cases. I can't say these things happen every week, but this has led to problems and has led to a sense of betrayal. So I think it's not a contractual fix. It's more, if because this really happened. We had a very large American company. They bought a Malaysian company. It's an industrial company. And the Malaysian company had a joint venture in China. They had gotten legal advice that they didn't need any permissions. They didn't need to do anything at the China level. And that was true. But after a few months, the Chinese partner complained about it. We ended up having, I think, 4 separate types of litigation. I don't know. They would have probably had problems anyway. But, this was something which was a trust issue. The Chinese partner really felt it was an incredible betrayal of trust that they basically changed the joint venture partner on them without even telling them, without the Americans even meeting them. The Malaysians just executed the sale, and the first time the Chinese found out about it was because they wanted to change the directors. So that was probably not the best way to approach the matter.
Do you think that's because of the comment you made earlier about status quo?
No, well, that is the opposite of status quo. That's a big change, but you didn't tell anybody. I just think, it's your first point was these things are all about people to people stuff. And I think that's why, even if a contract allows you to do something, it doesn't mean it's going to happen in real life. So, that isn't the way you would treat a partner. I mean, I'm sure the American company, if somebody did that to them, if the Chinese partner just fully changed its whole, ownership structure without telling them, they'd be talking about this for years. But,
All right. I'll get that question, Serena, in a little bit. But going back to what you said earlier, Mark, the 3 options that you really have to consider are mainly about how much are you going to pay. So, in your book, you mentioned that you said something very, I thought, interesting, is that leverage doesn't determine the outcome; it determines the price of the outcome. Do you want to go a little bit into detail about what is leverage and how to use leverage?
So I think, probably I have changed my view a little bit on that. I think, back then, because when I wrote it, that was really where, it was a world where you wouldn't even imagine the Chinese partner would buy out the joint venture partner. That's it was a different world. It was, but now if I look at the disputes we've had in recent times, probably almost half of them, it involves the Chinese side buying out the foreign side in the joint venture, and then the foreigner doing his own thing, in a woofie, or maybe he found some new partner. So I think it's a bit about the leverage. Look, the outcome, I think, based on the experience I've had, is we've been lucky enough that all of these disputes did get resolved, except for one. Okay, there was one which wasn't resolved. But, almost all those kind of joint venture struggles, there was a resolution. And if it was relatively, early in the old days, like I said, if you were going to buy out the company, then it was a question of the price. And so that was always going to be the outcome. Now it's a bit more complicated. And secondly, I'd say Chinese partners, and I'd say especially state-owned companies, they are impervious to time. They really don't feel time. It's just, where the foreigners are going crazy, if you just, the Chinese, they're just like, they'll Yeah, I remember I was walking down Changlaloo once, and there was that like a tricycle, those kind of tricycles, and the guy had all these gas bottles on it, this Chinese guy, and he's putting these gas bottles, and I actually stopped and I was looking and I thought, these tricycles are much more strong than I expected. Anyway, I was thinking that he put one more on, and then the wheels just buckled, like they just crumbled. And Changlaloo is a relatively busy road with cars in both directions. And these big gas cylinders are just going across the road in every direction. And I was thinking, God, what's he going to do now? This is going to be very pressure. This is real pressure. This is a disaster for him. And what he did was he looked, he took out a cigarette, and then he sat down by the road and had a cigarette and smoked and reflected about the situation. So I think this is the thing, very often the Westerners, they are very, very excited, but they only have bursts of things. They'll be very excited. We're going to do something next week. And then they do something, doesn't work. And then they go to sleep for a few months. So I think, the outcome is going to be likely. I can normally guess what is going to kind of happen. And so I think leverage will determine how quick and the price. So I think it's probably also that. And so when we look at leverage, we look at the leverage of the other side on you as well. So if you've got that exclusivity clause, like I said, we've got a client at the moment, they're asking about this question because they have an exclusivity clause, but it only binds them. And we've seen cases where Chinese partners have been able to enforce exclusivity through preliminary injunctions. And so I'm always a bit nervous about that because we've had a few of those cases. But then I think you also have to look at the other side's weaknesses. And it's difficult to just say these are the top 5 or something because things will really be bespoke. It really depend on what company, what sector, what business, all these kind of things. And then I guess you have to look at what's the process. So once you've worked out what you want to do, how do you do it? How long does it take? Have they breached the joint venture contract? And so maybe I'll just give here some ideas about leverage. The contract's nice, breach of the contract, it's nice, it's good to have that. But there might be other leverage, if it's a big state-owned company, maybe, forcing the closure of the operations an issue. But maybe, they've got 500 employees in that joint venture, but they've got 20,000 employees in the town. And so if you do some sweetheart deal and, buy it out and give the employees a big salary increase, this might be a much bigger problem for the state-owned enterprise than letting the company just continue in a zombie-like state. So you have to think a bit about how, whereas a private enterprise, he'll care about the money. State-owned enterprises, you have to do a bit of thinking about what we're really doing. So employees can sometimes be a leverage. If it's a lot of employees, you can rile them up because then they will rile up the local authorities, and the local authorities are the best source of pressure on the Chinese partner, be they private, be they state-owned. Accounts receivables, what we did in one case was when we realized the joint venture was not going in the right direction, the client just started buying more and more from the joint venture, but not paying. So basically, they engineered a big debt, and the Chinese joint venture was happy. Oh, we got lots of revenue, but they didn't realize you have to actually get paid to realize revenue. So that was an issue. And then I think IP breaches nowadays much more than it used to be. But nowadays IP breaches, because very often the Chinese partner will have other businesses, and so that kind of IP breach can really affect their reputation. Local authorities, perhaps things have changed a little bit in the last 5 years, but local authorities want foreign investment to come into their place. And so especially if it's a place like Suzhou or someone who really has a lot of foreign investors, having stories where the foreign investor has a problem, that can reflect badly on them. So sometimes, the local authorities, then supply chain, maybe you are actually part of the Chinese partner's supply chain. That can be an issue. Reputational damage, again, something 10 years ago you wouldn't have thought of, nowadays more important. And then I just quickly say, the other leverage is, which I think is very crucial, especially with private-owned companies, is look for anything where you can hit them overseas. Because within China, they feel pretty powerful. They feel very often insulated. They feel protected, they know how it works, they know all this stuff. But it's the opposite for them overseas. You know, they feel nervous about overseas, especially if they have overseas assets or business or residency or kids studying overseas. So that overseas thing, again, is something that wouldn't have been the case 15 years ago, but much bigger now. As the Chinese companies have gone abroad, they have introduced a level of vulnerability which wasn't there before.
Mark, just to go back, you know, a lot of this you covered in your book 15 years ago. You know, all of this leverage that you've picked up over the years, would you, is it because you know, back then things were negotiated rather than you know, gone slogging through court, so you've picked up a little bit of this practical application of leverage?
No, I don't think so. Look, I think it's really, I mean, look, I'm sure there'll be people online who've got different experiences, especially people who are in litigation. But I've never seen litigation solve a joint venture dispute. You know, I've seen it. I've seen court judgments. I've seen arbitration awards, but it just added stress or added pressure to come to the settlement. But, you know, I've never seen the court say, do this, and then one goes, oh, okay, it works. So I think the leverage is as important as it used to be, but it's just more complicated because there's many more options. You know, it used to be you will buy them out, what's the price? Now it's like, well, how do I deal with this? How do I deal with the employees? So it's more complicated. But I don't think the courts solve anything. I mean, other people may have different opinions.
And one of the points here under the leverage was local authorities, and you said that local authorities was the best source of leverage. How was it done back you know, 15 years ago, or even before that? Were local authorities more like mediators, like unofficial mediators in a sense, or how did that usually work out?
Well, I mean, it would depend on who the company is, and you know, if it's a massive state-owned enterprise, you know, in a small town, well, yeah, the local authorities, yeah, they're not going to do anything against those guys. Yeah, but yeah, typically, you know, most joint ventures aren't with those companies. So I think, you know, today I would say it's still the same. One of the first things I would look at is how good a relationship do you have with the local authorities? Most foreign joint venture partners never bother to build any local relationship. But I'd say at the starting point, I would look more towards reaching out to the authorities before I would reach out to the courts, because, you know, it's direct and you want a negotiated settlement. And I think the courts, like I say, and I hate to repeat things always, but, you know, I don't think they solve anything. They just bring additional pressure to bear that you actually will have to resolve it. So it just adds more pressure. It doesn't solve it itself.
We've covered a lot of these points here, Mark, but if you just want to quickly go over.
Yeah, so I mean, maybe it's worthwhile just summing it up a bit. So I think, you know, look, one of the things is people think if they write a letter saying, I have hereby terminated the joint venture contract, that somehow this dissipates. It's not the case. Even if you start litigation, it doesn't really mean anything. The joint venture continues. And the only way you get out of a joint venture, you know, something in China with your company name on it, something that can be directly tied to you, is if you either liquidate that company or sell your shares to it, or you buy it out and change the thing. So I think, you know, this is one issue you have to really think about, is it's not easy. Even if it takes a long time to make the decision that you've got to get out of it, it isn't as easy as writing a letter. And then I think, you know, the interwovenness of the global supply chain, very often we've had clients, okay, not that often, we don't get that many joint venture disputes, but, you know, it's quite common that the international company says, well, the joint venture relies on us because we're their biggest customer. And, you know, the Chinese side's thinking, well, you know, the international company really relies on us because we're their biggest supplier. And so I know that people think the customer is always more important, but if it's a complex piece of equipment, even if it's not that complex, if it's a mold or it's things like that, how, you know, and you're only getting it from one company, how do you deal with that? So this, interwoven complexity, and sometimes this is not appreciated by the people who are doing the strategy. Okay, we discussed status quo, not momentum, and Star Wars is that third Star Wars movie where of the sequels where it's always about Obi-Wan Kenobi having the high ground. Yeah, this is also the case in these joint ventures. It's not the law is biased. It's not even courts are biased or authorities. They may be biased in second, third tier cities, but it's just because it's their home ground. And I think it's worthwhile repeating and repeating again. For these joint venture disputes, for the international side, it's almost always just a hobby. So they spend a bit of time, but it's not their main focus. Whereas the Chinese partner, he's able to make decisions quickly. The international partner, they normally can't make a decision quickly to save their lives. Everything is slow. Everything is super safe. Everything is conservative. Everything gets vetted. And so by the time you make a bit of a decision, the facts on the ground have moved on, like 6 months in a 6-day process. So this I think is a major issue for them. And I'd also say, because I'm a bit concerned that I might come across as saying, litigation in China is not good or enforcement's very difficult. But I think they're difficult everywhere in the world, So I think it's expensive, it's difficult, and it's indirect wherever you go in the world. And
So just to go back to Serena's question, she asked, how do you enforce a call option right in China? I think I'd make it a little bit more general about how do you enforce any of your contractual rights in China, considering what we've been talking about in terms of you just said that it's not a bad thing to rely on the contract, but can you please just give us a little bit example about how to enforce your rights?
Okay, so a call option, I think it's a good example. So I mean, I'm sure everyone knows, but so like a call option is just in your contract. So let's say I've got a 70% shareholding, Sean, you have a 30% shareholding. Then if something happens, I've got the right to buy out your share. And so that sounds like a good idea, and it is a nice idea. But I think the problem in practice is they can be difficult to negotiate. Okay, so the other issue will be sometimes then people will want to have a put option or a call option. So a put option is that the Chinese partner would have the right to sell his shares to you at some stage. So call option is often thought of as this magic bullet, but let's just assume you do have it. The next problem is the calculation of the value can be difficult. Of course, you could legally assign a value. You could just say, okay, it's this much money or whatever. But very rarely is that the case because people don't know. The joint venture hasn't even started. So, it's hard to assign a very specific value. So there'll normally be a valuation process. And then I think the third one is, in China, it's not easy just to, sell your shares to somebody. This has to go through the registration authorities. You need a new business license. You need all these things. And so again, it needs cooperation. So I think having a call option is good, but what we could do is if everybody agrees, you would make it as simple as possible. You would have a power of attorney from the Chinese side that you could sign like a standard form share transfer agreement. But tell you the truth, very few people do this with strategic joint ventures because, I think you have to look for the exit when you're entering a joint venture, but that level of mistrust and everything, it's very difficult to negotiate. So that's just real life. So let's just say, even if you have the perfect call option, it will be the process. So the process will be, okay, the joint venture contract says very clearly, you will appoint a valuation company, I will appoint a valuation company, and then they'll get together and all this. Of course, if you've got a dispute, nobody appoints the valuation company, they don't recognize. So I think the difficulty is, it's worth having, but you have to realize, if you can't get the Chinese partner to agree to the concept and continue to cooperate, you have to go to the courts. And again, courts, they can order these things, but it's difficult. And then, with the call option, it's important to know are you able to negotiate something which is simple enough that you could actually enforce? I think that would be the issue.
I think it just goes back to the point that all of this goes beyond paper. You're dealing with people. So if you don't have cooperation, things are just not going to go smoothly. And well, I'll move on to this case study where the names, have been removed to protect the innocent. But it ties into the comment in the chat from Hui Zhou, our KWM Frankfurt colleague. He says that when he worked in China 15 years ago, his impression in the dispute was that the Chinese courts would favor the Chinese party because that they would kind of see them as, those are our companies, those are our parties, and they need to be protected. So, Mark, I guess maybe if you want to use this case study as an example, but he's asking, what is your experience with dealing with that?
Yeah, look, I think on that court case, I mean, look, I'd say, we had lots of these kind of disputes over the last 20 years. And, there's only been like one or two, actually, there's been two cases, and they were both in the same city with totally different clients. And so that city, if someone mentions that city, I would say, yeah, you better watch the courts in that city. But I think, in most places, I never really had the feeling that the Chinese courts, especially in first tier cities or whatever, I never really had that sense of over bias. I think there's some issues to look at. Firstly, often those contracts, even the best contract in the world cannot, explain what's going to happen or be prepared for something unexpected. And so the judges will often have a discretion, and they can decide reasonably between two, what's gray. There's the black position, the white position. The judges have a certain level of discretion. And I don't even think that, if there would be a criticism of this, and it may be a bit more cultural, I think it's rare for these Chinese judges to really have a 0 or 1, like a binary decision, So I think if you go to the courts, the judges in China are always trying to find a middle ground. And so even if you're 100% wrong, somehow their judgment will be still, oh, well, you're both kind of wrong. You're 70% wrong, you're 30%. So perhaps for a Westerner who does London maritime law, where I understand that it's really binary, either win or you lose, Chinese courts kind of try to make everybody a bit happy or a bit unhappy. And so I think that's the case. Now, in that one city, which starts with a C, which I won't disclose the whole name, but those courts were out of control. But in both cases, they weren't state-owned enterprises. They were private-owned enterprises. And I think there was no, corruption in that sense in those cases. But I think it was, the city was small enough that, it was a bit they happen in Shanghai, or of course anything's possible. But I think you have to really analyze who's your opponent, where's the location of the trial, and what kind of tricks can people play. I think it's not easy enough just to say, oh, the Chinese courts are always on the Chinese partner side. That at least hasn't been my experience. This case study, I mean, I think we don't really have anything in this case study. I think it just talks a bit more about like how these things kind of normally run. And so I think, look, the first way I would do it is, the people that, no joint venture that I've come across has really been an independent legal entity. They really are the two shareholders doing something together. So I would normally, once you realize there's a real problem, I would normally have an informal shareholder meeting and not a board meeting. And one of the other problems we have with board meetings is very often from both sides, management is also sitting in the board. And and then that doesn't really allow for a dispassionate discussion. So obviously the international company will listen to its management, which it's sent to China, for their stage. but I think it just adds a lot of emotion if you make it a formal board meeting. And so I think, it's best to have the shareholders, and we sometimes now put in the joint venture contracts like a kind of a dispute resolution, or I don't know what you call it, but like it's an informal process where if there's a problem, instead of going straight to arbitration, or doing the 60 days or 30 days notice or whatever, firstly, the CEO of the Chinese partner and the CEO of the foreign partner, they should meet. Because I think we sometimes try to think, how can we diffuse it? And then I think, once you do it, if you really can't come to a solution, I think probably the foreign partner, because in all the cases we have, it's the foreign partner who wants to leave. I really can't remember one case where the Chinese partner says, I want to get out of the joint venture. I can't remember one, because I think the Chinese partner will just ignore the joint venture and do their own thing, next door or even within the joint venture. So I think, if we're talking about who's making the momentum to change something, it's always the foreign side. And so I think you need, if you can't agree formally, informally, then once you get to the formal proposal, you've got to really know what you want, and then tell them, and don't already, and then also say, look, we prefer to do this, through discussions, etc., etc. But then start building the subtle leverage. For example, those guys in that dispute I mentioned who started ordering like crazy from the joint venture, they didn't send a letter saying, I'm going to sue you next week, and here's an order for 1 million, vials of pharmaceutical products. Saying, it's not that way. So, let people know what the issues are, but then start building your leverage, start collecting the documents, start checking things, start getting emails, start getting things confirming what your arguments are. So this might be a 3-month, 6-month process, but start early to build a case before you have the problem. And I think, most Chinese partners' response to your formal proposal, they'll just, actually most likely to still sounds like they're actually doing something. Mostly they'll just think, oh, well, whatever, they'll do nothing. They'll either do nothing or they will take steps to just take over the operation. So you have to be a bit careful not to over-egg it, that you force them. And then I think once you've got that and you kind of realize you're in possibly a toxic situation, and I know I go on about it, but if you could diffuse it, the worst deal you can get through like cooperation at this stage is highly likely better than the best deal you can get through a war, So, it hurts people, but if you can get something agreed, it'll be quicker, it'll probably be much cheaper, and it'll be less disruptive. And, after 6 months or a year, you will forget about it. But, if you start a war, this might be the next 2 years of your life, and it will take a while. So if you really feel you've got no choice, then you have to start working out how to increase the pressure, build leverage, and start with letters and things like that, notices, start, making it clear to everybody that you are backing up your case, find the leverage. And then the other important thing is escalation. So when we do this with a few clients, I think with the last client we did, we had a list of like 20 bespoke things that they could do. But you don't want to hit everybody on day one, because, a lot of that was going to be like cancer therapy, radiotherapy for cancer. It was going to kill the joint venture as well. And our client just wanted the Chinese partner to buy them out. And so we started escalating, and we started with things that were within our control, things that could be easily stopped. But, there were even things on there, for example, that our client had international companies as clients, which the Chinese joint venture put on its website without permission and things like that. But, what we did was we had those long lists, and it went further and further. And there was also fraud involved. So, thinking of going to police, you can't threaten, the police, because otherwise you'll be doing blackmail. And also the other thing, if you go to the police, you can't stop that. So these kind of things all have to be very low down. And then the escalation strategy, and in the end, it's actually only a few weeks ago, the Chinese side has now transferred, something like £6 million to buy the shareholding. So we didn't have to go far down, but it was good to have the whole plan ahead of us. And then you have to have some strategies about what happens if there's a deadlock, what happens if the employees strike, what happens if they freeze the bank account. You have to work out where are the chops. If you've got 70% of the shareholding, then you should be in charge of the manager. How do you protect those kind of things? So I think this increasing the pressure, building leverage, this is where you really try to work out those things. And then I think if you're successful, sign the documents as quickly as possible. We've had cases where the deal was 95%, and then somebody in headquarters wanted to improve it just a bit, to draw legs on the snake, to make it more beautiful, and then it just failed. There was a case where we're dealing with very, very different type of case, but basically a client was offered, I won't say the real figure, but they offered something like $300 million for a business. But the lawyer, for some reason, I don't know what the lawyer got, he thought, oh, you can get a better deal than that. And 4 years later, they can't sell that for $1. So, it's important to do it quick. Once you have an agreement, as long as it's not ridiculous, move quick, get it signed, start the implementation, keep the momentum going, because status quo will kill these kind of things. And then if you're unsuccessful, then we have all the other issues, which is going through that list of the escalation steps, doing things at the board, liaising with the authorities, writing a letter to terminate the joint venture. You have a PR, media strategy, legal actions, everything else. None of that is fun. That is expensive. It's time consuming. It's distracting. It's all this stuff. But, I'm not so naive to think it doesn't happen. And so those are the kind of things people have to work out. And so I think that's the issue. Again, I know I've mentioned it a few times already, but the problem is very often joint venture disputes, it's run by the people who were involved in the running. And so they come up with a strategy to punish the other side. But that's not what you want to do. Every punishment you do will normally damage the business, which means it will cost you money and it will also make it more difficult to resolve. So the more damaged it is, the less valuable it is. So, work out how to escalate properly. Don't just, stay off for no reason.
And business continuity is in everyone's best interest unless you're using it for leverage too, which is one of the points that we wanted to mention on the box.
But that's a weird thing, like those joint ventures. It's a bit like Germany in World War II. I think they said that even after they had bombed Germany, 70% of the factories were still capacity was still operating, and so all these joint ventures. It's one of the most amazing things I've ever seen. Is you've got people, suing each other. You've got people like kidnapping people. You've got people threatening violence. We even had a murder once upon a time in a far-flung province. We have all those kind of things going on, but they still send the products out. They're still selling stuff. So it is very strange. There's this incredible war going on, but on the other hand, they're still shipping out product, and the joint venture is kind of operating in most cases.
Well, the list of the main takeaways that we wanted you to have after this two-part series is on the screen. We won't beat it over your head again, but I guess this was a very interesting topic for me, coming from the whole looking back at China's past to your experience with China in the past and the way that it is today. And I think what I'm understanding is that the courts, even though they weren't as involved before, it is good to have a system that's comprehensive and is an avenue to resolve these disputes. But of course, the ways of the past are still as useful as they are today, it seems. And we should look at all the options on the paper and off, just so that we have an idea of how to best go about this terrible circumstance if it does happen.
Yeah, but so I think sorry, I'll just say one thing on that. I think it is a Western kind of concept that somehow Westerners have this concept that the courts are fantastic, but the courts, even in America, you have you have this election. And at the end of the day, it's not really about who gets the most votes. It's going to be like, well, what do the courts say? You know, everyone says, oh, let's get those, you know, people who are normally conservative elites of that society. And I think it's always a bit strange. It's something where I really think in China, the courts, really, it's a failure if you have to go to court. You do have to go to court, and the courts aren't as bad. But I think the idea of going to the authorities for assistance to resolve it, it's a good move. And it isn't something which is corrupt. It's something, you know, it's a bit different. You know, nobody, I think, in the West would think, oh, I've got a problem with my joint venture, my Chinese joint venture partner. Let's go talk to the Munich, you know, mayor or something. I mean, like the Munich mayor would go, I don't know, what are you guys doing? But in China, it's normal. So, you know, it's not untoward. It's not bad. It's a good way, and they can play the role of mediator. And I think that's something that people don't think about.
Yeah,
So,
a lot of these topics. No, it's great. I think a lot of these topics are, you know, pointing out some of the minor differences between maybe some Western jurisdiction and China, but it seems specifically for this joint venture stuff, disputes, that this is, you know, starkly different from where people might be experienced back home. So thanks again for watching. I think the reason why, one of the reasons why we wanted to cover this topic, we understand it's very niche, and thank you again for joining and watching. But these types of disputes, like Mark mentioned, usually do kind of creep up on people sometimes. So we wanted to cover it early so that we can put it on the YouTube channel. And if you or if someone you know is going through a problem, you know, we wanted to serve as a kind of a resource that you can turn to in the future. But of course, the next episodes will not be as niche. We will go back to some of the more bread and butter China business topics that we hope that you will enjoy. So with that said, the next one will be in 2 weeks' time. And thank you so much for watching. Take care. Thanks a lot, Mark.
Thanks, Sean.